Hello everyone, welcome to the Law of Torts lecture series. My name is Abhishek Singh Negi and today we are going to talk about constitutional tort. But before talking about constitutional tort, let me explain you that what are the things we are going to cover in this video. So we'll start with concept of state first. Concept of state is very important as to the whole debate of constitutional tort, which talks about that how the involvement of state in day-to-day life of the human being has changed the concept, the understanding of state, and how the constitutional debate, the constitutional tort debate is relevant as a changing understanding of the state. Then we'll talk about the sovereign function, as in there are certain functions which are called sovereign functions and there are certain functions which are called non-sovereign functions of the state. And we'll see the function of the state through the lens of sovereign powers test. Then we'll talk about Article 301 of the Constitution of India, which talks about that the state or the center can be sued or can sue. Then we'll talk about the pre-constitutional judgments, the pre-constitutional decisions regarding the sovereign and non-sovereign function of the state. And then we'll talk about the post-constitutional judgment as to what is the understanding of judiciary after the coming of Constitution of India. Then we'll see that can a person sue the state when it comes to civil wrongs only. What about those cases related to Article 21? What about those cases where the custodial death happened? What about those cases where rape happened in the state premises? So we'll talk about in the remedies very two important judgments, that is Neelavati Behra and Nageshwar Rao. After that, we'll talk about the international practice of UK, that how UK through Crown Proceedings Act 1947 has evolved the notion of constitutional tort. So starting with the concept of state. The concept of state, students, is very important in today's debate. Why? Because the state notion in earlier understanding was the police state, where the state is only there for the administration of justice and for the control of law and order situation. But today, the concept, the idea of state has been changed. The idea of state in today's generation is more and more peculiar. Why? Because the involvement of state is very much when it comes to economic activities. As the involvement of state is apparent and more prominent as compared to earlier days, the involvement of state and in the individual life has become very important. And as the state is getting more and more involved in the private person's life, the issue regarding constitutional tort is becoming very relevant. Now coming to the sovereign function. As we all know that the concept of state has been changed, it has no more become a police state but has become a welfare state, where the state has the liability to serve you, to feed you. And what amounts to constitutional tort when the employee of any government does any wrong or negligently hurts the private person? Can the state be held liable? To answer this question, the judiciary has evolved a test called sovereign power test, where they say that if the function of the state is such that is sovereign in nature, the issue of tortious claim cannot arise because the employee is doing the sovereign function. This is called sovereign powers test. That as to what is the function involved. For example, can we say that driving of army truck is a sovereign function? Can we say that the function of the doctor in government hospitals be sovereign function? So through the judgments, the judiciary have evolved, but so far there is no set parameter that when to say a function is called sovereign function and when not to say a function as non-sovereign function. So to answer this, we have Article 301 first. The Article 301 establishes that a state can sue or can be sued in the name of, if it is union state, then it can be sued in the name of Union of India, and if it is state, then it can be sued in the name of the state. For example, state of Rajasthan, state of Madhya Pradesh, state of Gujarat. Now, the most important case in pre-constitutional judgment is P&O Steam Navigation versus Secretary of State. Chief Justice Peacock delivered this judgment, and to answer the question that whether Secretary of State be held liable for the wrong done by the employee, the court answered in affirmative and said that yes, the employee for the nuisance or negligence of employee, for the wrong done by the employee, the Secretary of the State can be held liable through vicarious liability. And here, the first time through the Justice Peacock's judgment, it establishes that a person, no matter working in the government or not, if does something, and if the person could be able to prove that the employee has done something and that person is a servant of the government, the servant is vicariously liable. Also, we need not to ignore the concept of deep pocket theory. So, in a way, in P&O Steam Navigation versus Secretary of State, Justice Peacock said that yes, if the function of the state is non-sovereign, then every action of the employee and the employer will be treated as if he or she is the ordinary employee or employer in the court of law. That means if your function is non-sovereign function, then the East India Company will be tried in a manner of ordinary person. And in this case, as the East India Company was involved in the commercial and economic activity, and the Chief Justice Peacock said that economic and commercial activity is not the sovereign function, hence the East India Company is held vicariously liable in this judgment. But you have to prove first that the act done by the employee is non-sovereign function. Now, to what is sovereign and what is non-sovereign has not been clear now. Nobin Chandra Uday versus Secretary of State, in this case judgment also, the court said that issuing of license by the government is a sovereign function, and hence this is a sovereign function. The person cannot be able to tortiously claim against the government. Here also the court has not talked about what amounts to sovereign function and what not amounts to sovereign function. Secretary of State versus Haribhanji, Chief Justice Turner gave the very narrow interpretation of the term sovereign function. He said that only those functions which are directly coming from the sovereign are only considered, that too without the sanction of the statute. That means if the statute has sanctioned certain act, no matter if it is coming from the sovereign, it is considered that they are non-sovereign and they could be claimed against the tortious liability. After this judgment, the most important case in post-constitution judgment is State of Rajasthan versus Vidyavati. In State of Rajasthan versus Vidyavati, the facts of the case are the employee of the government met with an accident with the private individual, and the private individual succumbed to the injury. The wife of that private individual claimed vicarious liability against the state, as the person was the employee of the state of Rajasthan, and here the vicarious liability could be established against the state of Rajasthan. The court relied on P&O Steam Navigation versus Secretary of State and said that yes, since the act done by the employer during the course of employment, and here driving a vehicle of government is non-sovereign function, and since driving of the government vehicle is non-sovereign function, the employee working under the employer, both the person would be held liable, and employer, that is State of Rajasthan, is vicariously liable in this case. But after this judgment, a very controversial judgment in the name of Kasturilal Railalam Jain versus State of UP has come. In Kasturilal Railalam Jain versus State of UP, one of the constable took the seized property of the person and flew away. The State of UP said that since the seizure is the sovereign function and the seizure could not be claim against the tortious liability. That means if the police has seized something and that property has been taken away by someone, since seizure is a sovereign function, the person cannot claim tortious liability against the sovereign function. And court also gave the judgment in the favor of State of UP and said that since the seizure is a sovereign function and it cannot be claimed in the court of law. This judgment was a very controversial judgment and so far has not been overruled, no matter it has been criticized by the Supreme Court and many jurists time and again. For example, the CROI, very renowned critique of the Constitution, has said that the Supreme Court is wrongly interpreted the word sovereign function and got confused between act of state and wrongful act of the employee. He said that this is the wrongful act of the employee, rather act of state. In Shyam Sundar versus State of Rajasthan, this is a judgment where the employer, that is State of Rajasthan, was held vicariously liable for the famine relief worker, as the famine relief worker went in the direction of his employer, that is State of Rajasthan, and there he died. The person claimed that since the employer is State of Rajasthan, the State of Rajasthan should be held liable, and the court said yes, this is sovereign relief work, is not the famine relief work is not the sovereign function and he should be held liable. For example, in Delhi Municipal Corporation versus Sobhagwanti, here this is also called clock tower case, where the maintenance of clock tower was not done by the government properly, and since the maintenance has not been done properly, and because of the negligence of the government and one of the employee of the government, it fell down and it injured the person. The wife of that person claimed the damages against the state, taking that the state is vicariously liable since the employee acted under the employer and employee were negligent for the maintenance of the property. And the court said yes and relied again on P&O steam navigation and said yes, this is not the sovereign function and here the employee acted negligently. Again, in Chairman Railway Board versus Chandrama Das case, here the rape of the woman is held in the guest house of the railway station. Here the court said that maintenance of guest house is not the sovereign function and the state through vicarious liability has to pay damages to the woman. Now these are all the cases regarding the civil liability. But what about in those cases where Article 21 is coming into picture? For example, in Neelavati Behera versus State of Odisha, here in this case, this is the case of custodial death where the son of Neelavati Behera was killed in the custody of the police, and the court said yes, custody, no matter it criticized the Kasturilal Raligaram Jain case where it said that seizure is the sovereign function. Here the court said, in Neelavati Behera, the court said that since the custody is the function of the police, but if the police is doing any act wrongly, it is making the state vicariously liable. And here also in Neelavati Behera judgment, the court said that state has to give the compensation to the person. In Nageshwar Rao versus State of AP, the facts of the case is quite similar with Kasturi Ram versus State of UP. Here also, the employee of the government has seized the property of the person under Essential Commodities Act, and thereafter he misused that property. Relying on the judgment of Kasturi Lal, the state of AP argued that since the facts of the case is quite similar with the Kasturi Ram case, so in the Kasturi Ram it was held that search and seizure is sovereign function, and here also it should be considered as sovereign function. But court took different version, different path, and said that Kasturi Ram is a bad law, but the court could not be able to overrule Kasturi Ram because of the constitutional strength, as the bench is lower in number as compared to Kasturi Ram case. This case has not been overruled even in Nageshwar Rao case. And in Nageshwar Rao case, the court said only in the cases of repression of crime, maintenance of law and order situation, and administration of justice, only these are the cases of sovereign function. Otherwise, every function of the state would be considered as non-sovereign function. After that, in the international practice, the UK, where we have adopted so many things, in UK also there is something called Crown Proceedings Act 1947. There in UK, United Kingdom, the Crown Proceedings Act clearly states that any action of the government or the employee of the government can be claimed in the court of law. That means there is no distinction between sovereign and non-sovereign function. Also, they said that any action of the government can be claimed, can be challenged. But they have said that they have specifically mentioned that there are certain exceptions to it. For example, Proceedings Act 1947 specifically mentions that there are certain exceptions to the tortious claim. For example, acts of state, judicial function, armed forces, and exercise of prerogative. Other than these, the action of the state can be claimed against the tortious liability. That means there is no bifurcation when it comes to functions, as in sovereign function and non-sovereign function, as in India, and also that in India, so far, there is no specified definition that when it amounts to sovereign function and when it does not amount to sovereign function. With this, we have come to the end of the discussion. So far, I think it's all